air. Good day, everybody. Greetings during this open discussion of confidentiality as a basic principle of communication with the survivors, which is conducted by URFEM, Women Lawyers Association, in the partnership with Lawyers Without Borders from Canada, with the financial support of the Ministry of Foreign Affairs and Francophonie from Quebec. Before we start discussing the important issues today, which are important for our country and for everybody who is present, I would like to introduce our participants, Mr. Gonzague Dupas, legal assistant of Lawyers Without Borders of Canada in our Ukrainian project. Also, we have Ms. Larisa Denisenko, co-founder and member of URFEM, advocate, writer and media person, Mr. Irina Glavnyuk, a professor of Department of Criminal and Legal Department of the Institute of Internal Affairs, Mr. Igor Korol, head of the First Department of Procedural Management of Pretrial Investigations and Public Accusation in Criminal Proceedings on Crimes related to the sexual violence in the Department of Counteraction to Crimes committed during the times of war of the Office of the Prosecutor General. We are waiting for Mr. Victor Mesyak, who is the prosecutor of the same department of the Office of the Prosecutor General. Also, we have Ms. Daria Rosokhata, a lawyer and specialist of the Analytical Center of URFEM. So before we start, I would like to give the floor to Mr. Gonzague Dupas, who is going to present the project and tell a few words from our international partners. And also, I would like to say that we have a translation feature. You can ask your questions in Ukrainian or English languages, and we are going to respond. So, Mr. Gonzague, the floor is yours.
Добрый день, привет. Hello, everybody. It's a great pleasure being here with you today. My name is Gonzague Dupas, legal advisor for Lawyers Without Borders Canada. I'm really flattered and honored to be among yourselves today and to be able to attend to this crucial discussion on the issue of confidentiality in cases of sexual violence, especially conflict-related sexual violence. I think this issue is broader. The principles of confidentiality shall be respected for any kinds of victims, and as legal professionals working for the medias, we always need to respect this principle of confidentiality, since it's the very basis of the do no harm principle, and to avoid the renewal of the trauma of the victim. It's super important to respect such principle, since it's allows the victim to have a growing confidence toward the judicial system, toward the authorities, and towards the society in general. On the long run, having systems of confidentiality that are resilient with mechanisms of coordination between actors allows and fosters the engagement of the victims with the legal system, because in Ukraine, I believe, and as I've seen in other contexts, we can see that victims tend not to denunciate the violences that occurred, since they fear that for the confidentiality of their information, they have fear because of the taboo that surrounds certain kinds of violence, such as sexual violence. They also fear potentially reprisals. And having this strong and resilient system of confidentiality permits and allows for greater engagement from victims. So yeah, that's really a great pleasure and an honor once again to be here today. I hope the discussions will be fruitful, and thanks to all of you for being here. I'll give you back the floor, Katerina, and thanks again so much.
Дякую. Власне, починаючи цю дискусію.
Thank you. And In starting this discussion, I would like to point your attention to two basic principles that are very important in discussion of this topic. If we speak narrowly about criminal proceedings, we need to avoid intrusion into personal life, which includes such elements like no person can collect, use, share, or store data on private life of a person without a consent, except for cases provided for by the legislation. And also information about person's private life can only be used only for the objectives of criminal proceedings. Every subject, every actor that owns this information has to avoid the publicizing of this information. This is only one part of the discussion. At the same time, it is connected with another principle, such as openness of the court proceeding, which can be recorded by the technical equipment. So here we have the informal questions and discussions, which information can be public outside the criminal proceedings for the persons who are interested and who would like to own the information which is important right now. If we talk about the cases of CRSV, of course, there are latent crimes that are committed during the war, during the conflict. If we talk about the war of the Russian Federation against Ukraine, these can be those cases can be very significant. However, the numbers can be significant, but the number of open cases and the trends that we see can tell us that there are a lot of problems with trust of the victims, of the survivors during the criminal proceedings. They don't always believe that the justice will be achieved. Another important aspect, when we think beyond the criminal proceeding, there is a question of communications. Communications from the government authorities, the pre-trial authorities, the prosecutor's office on the one hand. On the other hand, there are the actors, the voices that people would like to trust, that the people are reading, I mean mass media. So the question is how to communicate information, how to tell the stories without encroaching on the private space of each person that can be related or who could experience these events in their lives. So that's why I would offer to discuss two important questions today. First of all, what kind of information which is related to the survivor or witnesses of sexual violence during the conflict. So which information can be accessible and which should not? And whether a person, before starting interaction between the authorities, should the survivors be informed which information can be made public and what additional means of protection they can have. Because before the start, the person has to understand which information can be made known to their community and to the society in general. So in order to start the question, I would like to give the floor to Daria Rosuchata and to her report, and then we are going to continue the discussion. Thank you, Katarina. Greetings once again to our guests and listeners. So if we talk about confidentiality in general as a basic principle of cooperation with the survivor, not only professional community, but all the Ukrainians and the entire world know about the crimes of Russian military and the atrocity and cruelness. Not only women, but also men and children can be survivors in order to suppress their position. So the crime of CRSV is, of course, has influence on the survivor, but also on their family and close ones and children. And publication of information about a person who has been a survivor of the CRSV needs special attention because of the nature and character of the crime. In general, we can see that since the start when the government authorities have announced the first cases of CRSV, we can see that the hunt has started by the mass media. Mass media has been hunting for those survivors who could become protagonists of the stories. And this search is also used by the criminal justice agencies in order to open relevant proceedings and recording the military crimes, the war crimes, in order to achieve justice, which is expected by the survivors. So during the search for these cases, a lot of people can forget about the principle of confidentiality as one of the basic principles. At the same, together with the principles of safety and respect. So this is a cross-cutting principle which should cover everybody on the vertical axis and horizontal axis as well. So it concerns all the actors. For example, during the application to the law enforcement, when people receive medical services, rehabilitation services, and during communication with the mass media. At the same time, also, this principle has to be present in the internal and external communications. As for internal communications, I mean interaction between the survivor and mass media, criminal justice, in private talks, in interviews, in provision of witness statements, and external communication. By external communication, I mean publication of stories in the open sources and in the mass media. So during the discussion, as Katerina said, we need to discuss which information should be let out to the media space and what information should be kept secret from the general public. We understand the situation, and we presume that we have a lot of cases basing on the reports by the international organizations, civil society organizations, and when a significant part of the territory of Ukraine is being deoccupied, we presume that we have more cases than are officially registered. That's why we have a question, why this tendency is present, why we have so few applications to the law enforcement. One of the reasons is observing the confidentiality, because we know that the problem of observing confidentiality sometimes has to be resolved by people who have never encountered this problem. It has to be dealt by the specialists and professionals in the legal space and in the area of mass media. If we talk about the legal sphere, we have questions about legislation and special trainings of the investigators and prosecutors who work with the survivors. If we talk about mass media, they also have their rules of communications and interaction with the survivors that have to be known and that have to be used in practice. So I hope that today, during our discussion, we will also touch upon this topic. Shortly speaking, the information publicized about a survivor should not allow to identify this person who has survived violence. If we talk about the impact of observing or non-observance of confidentiality, I mean, this has an impact on the openness of the survivor to the criminal justice system, whether he or she will be able to tell to the world what they survived, what they experienced. And disclosing the details of a crime can have significant impact on their private and family life. Yes, this can also impact their social status and labor status. Later, such survivor can be ostracized by other people, even close family. And also, there is a risk of ostracizing by other people. Also, the survivor can feel that they have shared a story, not with one person, not only in Ukraine, but they may have a feeling that the story has become public around the world, and this will not help him or her to receive justice, to get reparations and rehabilitation. after this crime was committed. We believe that this interaction with the survivor has to be as sensitive as possible, it has to be as responsible as possible, and each area of responsibility has to keep to confidentiality. Thank you. Thank you, Daria. And now you have mentioned different sectors, different areas of responsibility. I would like to mention, first of all, that probably every one of us has an impact on communications, and this will have an impact on how the survivor can return to their usual life after such crimes has been committed upon them. But talking about the subjects and actors who have influence on the survivors, we have representatives of the Office of the Prosecutor General, and they work in this field, and largely it is on them. It depends a lot. A lot depends on them whether the survivors will have a relevant protection during the proceedings. So a question is, how the law enforcement agencies, how the pretrial investigators and prosecutor's office, how do you ensure confidentiality to the survivors? Do you have any challenges that you are facing today? Or maybe there is some information that could be useful for us to hear from you as representatives of the prosecutor's office. Mr. Victor or Igor, who would like to speak about this? We can hear you. Yes, you. Good day. I'm sorry for the settings. We face certain problems every day, certain challenges. We have to ensure the confidentiality of survivors of sexual violence, taking into account the changes in our work, in our approaches that we are using right now. We hope we are improving the trust of the survivors in the law enforcement system. We need to explain to the survivor that we are going to change their personal data because the survivors are afraid that Russian military will return into the area. So when given testimony, they are afraid for their own health and for the health and life of their families. So we change the information. We keep confidential the information about the survivors and witnesses as well. Of course, we have to do it in the manual mode. We have to do it manually because the law does not oblige us to do it. So we are doing this as our own initiative. So we suggested to make some changes in the legislation. We suggested some changes to the bylaws, to the criminal procedural code. So we would like to change some clauses regulating the notice of suspicion, when the prosecutor is obliged to publish the full text of the suspicion notice indicating the data of the survivor and the location of the crime. So we have sent a criminal proceeding to a court after a rape of a local resident, in which, of course, we had to change the personal information. So we had to change the data about the survivor and her family members. And also, we had to change the information about a person who was threatened with physical violence. And we indicated only the name of the local community. We didn't indicate the street, we didn't indicate the location of the crime. I understand that we may have questions during the court proceedings, during the court hearing. Uh, Unfortunately, Mr. Igor disconnected. So while Mr. Igor is trying to connect again, greetings to everybody. I would like to say that yes, Igor has been telling us about some practical aspects. I know that he has been preparing for the meeting because his department is working on the procedural guidance. Of course, we're trying to send to a court a conclusion without indicating the specific scene of the crime, without specific location. Technically, our notice, our submission can be returned from court to us again, but on the other hand, we need to protect our survivor, and we do not agree to provide the open data. So we are trying to begin this practice, and then we will see the court's reaction, because the criminal procedural code obliges us to indicate exact information. We had a lot of discussions inside our department, and in these cases we understand that we have a risk that the court will not accept our documents. But on the other hand, if we disclose the personal data, the identifiable data of a survivor, also Igor will have some part to tell you. I would like to tell you about my work in the recent days. As for the protection of our survivors, we try to work comprehensively, and we try to make them feel really necessary. I'm sorry. We need to ensure not only protection during the procedures, but the survivors need to understand that we can help them. So we start interviews in the presence of a psychologist. Our department is very small, but we are making a lot of efforts. When we are interviewing people about facts of sexual violence, usually we invite a psychologist. First of all, a psychologist has to talk to this person, and then the psychologist can give us some primary information and indicate some red lines which we should not cross as professionals, as prosecutors, during our interviewing. We have established some cases of crimes during the interviews. There are a lot of different aspects and points. We have been visiting the territories. We have been working in different teams, in different working groups. Journalists from Berlin were asking us to take them to our survivors, and we were trying to ensure some possibilities for rehabilitation in the shelter, in the Carpathian resorts, or maybe abroad, maybe to use some civic organizations with which we cooperate to support those survivors, because they live like 15 kilometers from the front line. Of course, journalists were very interested to talking to these people, to the survivors. Usually we have a different attitude. We would like journalists to tell the truth. I'm sorry for the noise. Of course, we are interested that the journalist would explain the situation on a good level. The journalists really saw the destroyed equipment, the destroyed buildings and villages. They saw the shellings and bombings where our survivors live. Of course, the journalists are interested to talk to local population, and the locals say, this is the shelling, this is a bomb coming in, this is a bomb coming out. And so this was like an interesting thing for the journalist. I was talking to journalists, and my subordinates and our women subordinates and psychologists, they went to talk to the local people, to the survivors, to offer them some opportunities to have rest. Our survivors refused to talk to journalists, and the journalists understood this, of course. The journalists said that they all used to visit the events in Bosnia, like even a lot of decades after the events. Even after some decades, the survivors started to provide their witness statements. And they were very interested to hear from us that during the war, we already have the survivors who are ready to testify, and we are registering the testimony, which is going to become the evidence base for the aggression of the Russian Federation. We have a very comprehensive approach. You know that we have the interagency working group in the area of CRSV, and Katerina Kit is participating in the group, is the head of the group. So we entrusted Ms. Katerina Kit to be the chair of the group and to coordinate the group. It includes a lot of organizations, a lot of law enforcement groups. So I can see that more and more organizations would like to join our work. They offer their services to develop different documents. And during the expert group, we are discussing the questions about changes in the legislation, about changes in the approaches. Of course, the prosecutor's office cannot initiate legislative changes, but we can make certain options. We can make certain suggestions of what we would like to see. And through the public dialogue, through the public discussion, we would like to have streamlined approaches of law enforcement, of national NGOs, international organizations which cooperate with the law enforcement system. We would like to have the same vision, the same approach on how to protect the survivors. Igor says that he has some problems with the computers. I know that we have about 70 criminal proceedings. We, as prosecutors, we are having procedural guidance in our cases. We are going to prepare our prosecutors. We are not transferring our cases anywhere. We are going to be managing them. Well, of course, sometimes we make mistakes, and because of the mistakes, we can lose evidence. We should not be doing this. So far, we are working alone. Well, I can see we have more than 155 cases. We are doing a very big work. As soon as we get the information, we visit the locations, we take witness statements, we register the crimes. In order to have a correct approach, we are preparing the guidelines on types of the CRSV. I understand that sometimes they may have similar traits. Different types of CRSV have similar traits, but we need to provide our law enforcement officers some guidelines so that they have a better understanding. I didn't speak about the statistics yet, so probably Igor can speak about our statistics. Thank you. Thank you, Victor. So, Igor, if you would like to add anything. As for statistics, I'm not sure when I disappeared during my report. As for statistics, today we have 6 notices of suspicion. 3 cases have been sent to court. As for the criminal proceedings, sometimes in the proceedings we have 7 to 10 cases, 7 to 10 counts of sexual violence. We have documented 156 facts, but as for the proceedings, we have a smaller number of proceedings, but we are trying to use the specific number of survivors and facts. Sometimes it can happen that one survivor experienced 5 to 6 counts of sexual violence. So that's why we have such a big number. Thank you, Igor. Would you like to add anything about challenges? You stopped about the new practice of sending accusations without indicating specific addresses. Yes, I was talking about it. But I have some problems with my laptop. Yes, during this year, we are not indicating the specific addresses of crime scenes because this was in a settlement of Kyiv region when the sexual violence crime was committed against the survivor. So the criminal procedural code obliges us to indicate the address, but if we do it, everybody would find out her neighbors and her, because in a small village the information is spreading very quickly. So we had to change the personal data of the survivor. In this way, we allowed the witnesses, the family, and the survivor to avoid identification. So we had to change their names and surnames and addresses. And also we had to avoid indicating the address of the crime. Of course, this crime has been investigated. We know the exact address, the time and the way of commission of the crime, but we did not indicate it in our accusation papers. Right now we will be trying to change the judicial practice to, we hope, for understanding from the judges and from the court. We hope that the courts will not be returning us the accusation papers and that the courts will not oblige us to make changes. Thank you for this information. Thank you for sharing this about your work and about your challenges. Victor and Igor said that there are certain legislative obstacles or maybe some peculiarities of the legislation that don't always allow to ensure confidentiality of the survivors. And in this regard, maybe Miss Irina would tell us in more details about the peculiarities of the process. If we are talking about a criminal procedure, what are the peculiarities to ensure confidentiality of survivors and witnesses and what changes are necessary today, what changes in the legislation are necessary today to ensure the right to privacy. Thank you, Ms. Katerina. Thank you, dear colleagues. It was very interesting and useful to listen about your practice described by Mr. Igor and Victor, because this demonstrates that we need some new approaches to treat the survivors in the criminal proceedings. I hope that colleagues are going to agree with me that during our criminal proceeding, unfortunately, the survivor is the least protected participant of a criminal proceeding. This is really so. Of course, our code of criminal proceeding has a lot of European standards, but unfortunately, they don't have high standards in protection of privacy of the survivors. If we are talking about the CRSV, we have several basic points. The criminal procedure code, objectively, it can't, as a piece of legislation, the code has to have some special norms about notices of suspicion in certain categories of criminal cases. As we can see right now, probably we should not use the generally accepted norms, and we still have some work in front of us. Maybe we need to change the criminal procedural code. We need to do this, and we need to develop the changes in details. I know that Victor and Igor are afraid that their accusation papers are going to be returned from court, because technically they are not according to the law. And another point is that the accused person, however humane attitude we have, the defendant has a right to defense. The defendant has the right to know what the accusation is and the supposed place of the crime scene. We need to understand this. So when we develop the possible amendments to the criminal procedural code, we need to take this into account. We need to understand that the accused people, when they are going to be condemned, they can go to the European Court of Human Rights, and then we have to prove that we did not violate their rights. Also, the law on ensuring safety of people participating in a criminal proceeding, well, let us remember that this law was adopted in 1993. In the 1993, the parliament was not ready to the challenges that we have now. Of course, right now we are using, and representatives of the survivor can make a petition for the measures of safety, including limiting the information, limiting the personal information in the material, and they have some procedural means of protection as well. But all those measures are not sufficient to ensure safety of survivors on the international level, because the law says that we need to state that there is a real threat to the person if we want to hide their data. So, if you have mentioned that the survivors are located on the territory of Ukraine, near the front line, the survivors are afraid that the Russian army can return into their area. We don't have any questions whether the threat is real or not in this case. But what if the survivors are located abroad? We need to take this point into account. If we have a broader perspective on the issue, I would like to say that the problem is not only in the CRSV, but also it is connected with other crimes connected with sexual violence. I would, even if they are not related to the conflict, even without a context, because all those traits have a big importance. For a person who has survived a rape, not in the conditions of a conflict, they are also scared that their neighbors are going to find out, their family members, their work colleagues can find out, and so on. So we need to understand that we will need to resolve this question comprehensively. My opinion is that uh, however standard it can look, because very often we hear that the most widespread way of resolving challenges is to make changes in the code. But our colleagues are showing that they are trying to change the practice. But I believe that because of the challenges that we have right now, taking into account the need for confidentiality, not only because of the military conflict, maybe we need to review the basis of a criminal proceedings. Maybe we can make changes or additions in the other articles of the criminal code, and then we can expand them to the criminal proceedings in general. Let us be realistic. The question of confidentiality hypothetically can emerge not only in cases of sexual violence in the broad sense, but in any cases. When a person, for different reasons, we need to respect the right to confidentiality, basing on the Article 8 of the Convention, because there can be some reputational risks if the situation is disclosed about a person. People may have problems at work, problems in the family. There can be so many examples. I'm not talking only about sexual violence. So we need to find a comprehensive solution to the problem. And the life is helping us, it is pushing us to ensure confidentiality of survivors and witnesses as well, because we need to have a broad perspective in the situation, not only when we have real threat to the health and life, because those cases, of course, can be resolved, but sometimes it can have a negative impact on their personal life when this information is disclosed. Going back to the conflict-related sexual violence, our colleagues from URFEM were saying that there was a notice of suspicion, and in the notice they asked the prosecutor to close the identifiable information about the survivor. So, as far as I saw, in this case, the personal information was hidden, but there are many other cases that I saw on the website which contained the identifiable information, unfortunately. So we need to change our practices. As far as I've heard from our representatives of the prosecutor's office, they are trying to do this successfully, and we need to change the practice, and we need to make amendments to the criminal procedure code. In the criminal proceedings, it should cover not only CRSV but other cases as well. Thank you for the attention. Thank you, Irina. Thank you for your suggestions and thoughts. I would like to give the floor to Miss Larissa and point your attention that when we are talking about CRSV, we have to pay attention to the survivor, to the family members, but also we have to remember about the community, because a lot of people who have experienced these crimes are not always ready to talk about this because of how this topic is disclosed or discussed at different levels. So how these questions can be communicated? What can we do at our level as representatives of the law community? And what mass media can do to ensure the quality of communications? using the principle do no harm. Thank you, Katerina. Greetings, dear colleagues. I'm still receiving a lot of requests from the international of Ukrainian and international journalists when they see me as an opportunity or as a free shop, as a free window in McDonald's to make an order about different protagonists. They are asking me, can you organize a discussion with people survivors of group violence? Or they are asking me for coordinates of a person who was raped with the child or in the presence of the child. They are asking me to show them people who have survived violence, who are underage men or boys. So sometimes the cynicism is very big. Sometimes I receive such requests from Swiss media, French media. Well, they have sometimes even with a good reputation from the United States of America, from the Great Britain. So there is a big difference. Sometimes I get requests from military correspondents who used to work with this topic in Syria, Chechnya, and Syria, in Africa, sometimes, because professional correspondents understand on how to work with the topic. Some people know about the Murad code, and they understand the basic of communication of the survivors of sexual violence and protection of personal data. So, a priori, we think that foreign people are more sensitive, that they have more knowledge, and this is not always the case. And even our registrars who work with them, they are asking me to read short lectures to explain why this is not acceptable. But for the drama, maybe to make a drama of a material in order to satisfy their audiences, they are often asking to provide a realistic story from the first person. And they are insisting that people who are investigating the case, who are working in the case, sometimes psychologists and lawyers, they are asking the lawyers to provide contacts with the survivors. So my principle, first of all, is, so I believe that the first level of information safety have to be the advocates, the lawyers. If a person has a legal representative who is working directly with the survivor, because in some cases the survivors don't have a legal representative. I had a very flagrant case of violation of confidentiality and personal data disclosure. So it was a reputable media, the present time. Please don't confuse it with the new time. So this media, the present time, it's an international media outlet. So they published a material which we analyzed. So they were interviewing a survivor. They blurred her face. They did not indicate her name. So they sort of ensured the anonymity, but people could see her building, people could see the region, they could see the village, the name of the village, they could see it on a map, they could see her clothes. So of course, winter, so it's clear that she could be easily identified by her clothes, by her general look, because this is a small settlement. And by seeing her building, her home, her district, and the map, and her silhouette, she could be easily identified, and her voice was not changed as well. Also, I was outraged because a woman to whom she talked, they did not change the name of her neighbor, and she was describing how her neighbor was raped without changing her name. Of course, I have no question to the survivor because she was not prepared. She doesn't understand what she is doing. People come to her with a microphone, foreigners, and of course, she has an adrenaline rush, and she is talking about everything that was happening. So the journalist promised her that she would not be identified, but it wasn't so. She was identified by her neighbor, and she indicated the real name of her neighbor and thought that her neighbor was raped as well. So this is a very dangerous topic. This material was published in the beginning of April, and at that point of time, we were not confident that the Russian would not return to the same territory which was liberated, because the situation was still uncertain. There were, of course, the military could know this information, and of course, the journalists were brought to the settlement and they had this interview. So, because of this, I have a question. So, besides working with the journalists, I also have a question of responding. Maybe cyber police could do it. We need to discuss this, how we can respond when these materials are published. We need to be able to block those materials quickly. Maybe we should have a three-point test. Of course, there is a public interest in this material, but on the other hand, we have the protection of personal data, protection of this person. There is a threat to the life, reputation, and health of this person as well, and they have to be in the forefront. So we need to close some of the information. However, I insist that we need to ensure also the freedom of information, but we need to respond to those materials, because sometimes the survivors are not even able to see those materials. So when the materials are published and the survivor is trying to restore, to live their own lives, the survivor doesn't even know how to respond to such publications. And here we can't even expect the reaction from the survivor. So this is a question to our community about what we can do in these cases. I have another example about the topic of sexual violence, but not as a war crime, but as probably you know there was a media case about sex parties in Kiev when young men were drinking and intoxicating girls and then committing sexual violence against them. So the accusations used the media because the survivors did not give any evidence. And why it wasn't happened? Why it didn't happen? The content was shared by many people, and one of the survivors, people recognized one of the survivors and started discussing her personal life. They were saying that she was a sexual worker, that she didn't care about her reputation. And as a result, the other survivors in this case, other survivors did not want to be connected or to be associated with sexual workers. They didn't want stories about themselves in the Telegram. And because this was a very powerful case of hate and bullying. Right now, digital technologies allow to find different people in a very easy way, and to harass and to condemn the stalker even online. So different men and women started doing this. So that's why this story is a very good example in my case, in my opinion. So I have a statement from a mother of an underage girl in the area that was liberated in the beginning of autumn. So the mother says that in her opinion, her daughter survived sexual violence. On the other hand, she doesn't have a very good reputation in the village, the reputation that her mother would be able to be proud of. And because of her bad reputation, she is not able to make a petition to the law enforcement. So people start thinking about the background of such girl, of what people are going to say about her in the future. The society doesn't always treat you as an innocent victim. Very often, community is trying to discuss the background of such survivors under microscope. So there is a point of harassing and bullying, and another point is discussions. And when people express their acknowledgement in such a way that the survivor would like to commit a suicide, so then the discussions begin in the village. Oh, poor women, poor girl, what happened? And when neighbors, when people in the community start discussing those things, this can have very negative consequences on the mentality. So this also concerns the protection of personal data and confidentiality. And we need to continue our work we need to work on the attitude of the community, of men and women, attitude towards survivor of sexual violence. And we need to shift the focus from the survivors to the crime itself, to the condemnation of the crime and the perpetrators. As for the journalists, me and my colleagues, we have developed one of the first, well, globally, we have developed guidelines on how to talk with the survivors of sexual violence and how to cover those stories. It is available in Ukrainian and English languages. It was published on the websites of several international organizations, on the platforms of professional journalistic communities, so that we can share our fresh traumatic experience and to be able to develop a protocol of working and handling the survivors of sexual violence during the war. So I would suggest our law enforcement colleagues to review it, because it contains certain basic principles. If we observe those basic principles during our talks with the survivors, we will be able to avoid stigmatizing and re-traumatizing. And we need to show that our society is understanding and accepting, that our professional community is understanding and accepting, and we would like to restore the justice and protect people, and not just to spread some rumors around villages. And we need to stop speculating on the topic and on those people who have experienced atrocious crimes. So in the future, I can send you a link through Katerina. I can send you the link to the protocol, to the manual, but you can easily find it on the websites like Громадське Radio, Detector Media, on about how media should talk about sexual violence. You will get the search results and you will be able to see these materials, see these guidelines. I would also suggest this to our colleagues from the prosecutor's office. So You can review the guidelines, because sometimes we get very, very strange and inadequate requests from the mass media. I would like to get back to the things that we can respond to. If a video content is violating the personal data confidentiality, we can respond to that. I agree that the perpetrator is protected by the presumption of innocence in the beginning, and then the system is trying to preserve the confidentiality for the perpetrator and for the family members of the perpetrator. Usually they don't find it so interesting compared to the survivor, when mass media can go to the teacher, to the neighbors, to the friends, and asking questions about the survivor in the past and right now. So we need to think what we can do to respond when personal data is published in the mass media. Because what we can do with the mass media, for example, we have a commission on the journalistic ethics, and we also have an independent media council, but usually they have very lengthy proceedings. But in these cases, we need to respond quickly. And the conclusions of the journalistic ethic commissions are just recommendations. And in cases when we need to protect people, this process is too long, and this process is unjust to this person. Of course, the media reputation can be spoiled, but I'm thinking about the survivor, about her reputation. But as for the media outlet reputation, we can spend more time on that. Thank you for the attention. Thank you, Miss Larissa. The registered participants and speakers will get your manual. We know about the manual that you have prepared. Thank you for mentioning it once again, that it's there, and it is very important. And to conclude, because we don't have much time right now, so we also have representatives of different communities and different audience, first of all, and secondly, we need to understand that among our audience there may be people who are survivors of sexual violence, or maybe you know some survivors. So can we respond in one sentence if we ask ourselves what positive things have been done today in order to ensure the confidentiality of survivors, and what we need to do today to ensure the confidentiality in the future? Just this is an open floor, a minute or two, if you would like to say something. The first thing that has been done is that the survivors, I'm talking about the sexual violence category, right now the survivors have trust in us. They trust the investigators, the prosecutors, because they already see our new methods of work. We not only do we keep confidentiality, but also we forbid other parties to share the data about the crimes without a consent of the survivor. What we need to do in the future? First of all, we need to overcome some legislative obstacles, because we need to move our case forward without disclosing the confidential data of survivors. So we have been discussing the pre-trial process and the trial process. Even during an interview, even during the testimony, we need to use some new practices. Right now, we are using all the possibilities that we have to avoid disclosing the confidential information, and the personal identifiable information about survivors. And we are moving on. Victor, I would like to add to Igor's words that the examples that we have been talking about today, that we do not use some specific details in the accusation act. So we are right now we are working manually, but as prosecutors, we would like to be working within the legal framework. Since the start of the full-fledged invasion and the war, we need some changes in the legislation. So we would like to act according to the legislation as prosecutors. Of course, we are using the new methods thanks to cooperation with your organization and with international experts. So when this information is not shared, but we at the same time we work together to help the survivors and the witnesses in their cases. This is a very positive thing. And I would like to say this as a prosecutor, that we would like to see changes in the legislations that would allow us to work in the legal framework. Thank you. Ms. Larissa. Probably I would like to say a few words. Yes, indeed, this is a very literate and very sensitive approach demonstrated by the prosecutor's office, that you are manually trying to protect the personal data. We will need to look at the judicial practice, because probably during the hearing in court, it will be difficult for you to communicate with judges. But I believe that maybe we can achieve some changes in the criminal procedural code in order to make your work easier. As for the positive point, I like to see the reaction of the society to the traumatizing messages of our ex-ombudsperson, Ms. Lyudmila Denisova, that she allowed herself some bad publications. I don't say that this caused her dismissal, but I hope that this will lead to changes in the communications from different officers, from different high-rank officials, because they have to be very careful in their communications, and they have to protect the personal data of the survivors. It's very important that we have the response from the society, and the communications guidelines that we have come up. This is a new thing, and we hope that the guidelines are going to be used in practice, that they will not just remain in paper, because we have provided guidelines how to interview the survivors of war crimes, the survivors of the war. I'm not talking just about the sexual violence, but I'm talking about different war crimes, and this is another positive point. I would also like to say, I would also like to respond to Mr. Igor as for the consent provided by survivor. I understand that we don't always have time and enough attention, but the consent has to be conscientious, because very often journalists are getting consent from people, but they don't always tell about the consequences. So what are the consequences for you if you give your consent? From the journalists who can come up to you, up to different people who would like to poke their noses into your private life. Very often survivors give consent because they believe that they will help the society to find out. But as a result, the survivors get informational bullying, cyberbullying, and it's very difficult to stop it. So before giving consent, we need to explain about the consequences for the people. And we need to understand that the consent is conscientious. I would like to add a few things about informed consent. We have discussed it during our expert working group, and several organizations have joined their efforts to to try to harmonize the consent with our legislation in order to implement it in our procedural bylaws and use it in our future work. Thank you. Just a few words. From what we have heard today, we can see that a lot of things have been done, but unfortunately, we still have a lot of work in front of us, much more work, because we have a lot of factors, the bylaws, but also we have a lot of mentality factors. We can see that our society is not, the society is no longer trying to use the words like that's her fault, that's his fault. We are trying to stop discussing other people's life and intruding into other people's lives. But right now the situation is not very satisfactory in this regard. So, and we still have a lot of work in front of us in this area. We need to change the criminal procedural code. We need to make criminal proceedings more sensitive to the survivors, not only from sexual violence, but to other survivors as well, in the broader sense. Thanks to everybody for discussion. First of all, thank you for this specific professional discussion without any superficial things. Maybe we have some specific suggestions that we can use to move on, because everybody's objective is to do something to help the survivors and to help people in the locations to recover from the problems that we have, and we aim to protect the life, the dignity of survivors, and to give them the necessary protection, satisfaction, to bring the perpetrators to the responsibility, and to be able to live in the normal democratic society. Thanks to everybody for the discussion. We will be staying in touch, and we are going to share all the materials. If our audience or experts have additional questions, we are going to pay attention to that. I wish everybody a calm evening and a safe evening, and goodbye. Goodbye. Thank you, dear colleagues. Wish you a safe evening and fruitful work. Yes, stay strong. Thank you. See you. All the best.